So let's turn to the standard that you were kind of discussing earlier, the Monroe v. Pape case in 1961, and then the kind of chipping away at the attempt at bringing back some sort of ability for people to get recourse from police. Take us through how the modern standard that we apply to um, the, these issues of police brutality kind of happened in Supreme Court case law.
Absolutely. So there are a number of different ways in which the Supreme Court's decisions have chipped away at that right to sue. One of those is qualified immunity doctrine, which protects officers even when they have violated the Constitution if there isn't a prior court decision with nearly identical facts, and that has gotten a lot of attention. But there are other Supreme Court decisions that have a large impact as well. Consider the Supreme Court's decisions that just interpret what the Fourth Amendment to the United States Constitution means. That is a protection against unreasonable searches and seizures. But the way in which the Supreme Court has interpreted that language of the Fourth Amendment, police can stop and frisk someone walking down the street, stop their car, and search their car for really almost no reason at all. The court has described there needs to be a reasonable suspicion, but the way in which they've interpreted it allows that officers can make those stops on a pretext based on race, based on ethnicity, so long as they can come up with a justification afterward for the stop itself. There's similar latitude given to police when it comes to use of force. Police can shoot someone, assault someone who has done nothing wrong, who does not have a weapon, even who is holding their hands up in the air, so long as the officer says after the fact, "I feared for my life." If they have a reasonable concern that force is going to be used against them, they can use force themselves. And these standards are so vague that it really does give police tremendous power. I talk in the book about 11 different protections, but I guess I'll offer one more, which is protections against local governments. In the private sector, employers are directly responsible for their employees' misconduct. But the Supreme Court has said that local governments are not directly responsible, that they can only be sued for a pattern or practice of constitutional violations. And the court has made that standard very difficult to meet. So even in extremely troubled police departments, like the one I profile in Vallejo, California, where officers have bent badges in celebration of police shootings, and no officers have been disciplined or terminated for their conduct, courts still have found that the city of Vallejo is not or cannot be held responsible because the plaintiffs cannot prove a pattern of past constitutional violations.
That's incredible, because the amount of violations that you detail in your book, I mean, you just gave an anecdote there, but if you don't mind just speaking about Vallejo in particular, because that's such an extreme example of what you're talking about.
It is an extreme example, and it's a small-ish city near Oakland, California, with about 120,000 people and about 100 officers. And I really focus on the period between 2010 and 2020. During that decade, police officers in Vallejo killed more people per capita than all but one, St. Louis, of the 100 largest jurisdictions in the country. And I looked at lawsuits filed during that period of time. I came up with 85 of them. And again, you hear or read stories by people who had egregious force against them after they had been arrested, when they were handcuffed, they were tased, and they were beaten, they were kicked. I focus on a story of a man named Mario Romero, who was killed by a police officer in Vallejo after his car was stopped allegedly because the car looked like another car that had been involved with a crime. Mario Romero hadn't been involved in any crime, but he was shot more than 30 times in his car. And in fact, one of the officers had to reload his weapon, got up on the hood of the car, and continued shooting Mario Romero. And
Jesus.
Mario was one of 3 people that same officer killed in a matter of months in 2012. And yet when the family of Mario Romero brought this lawsuit against the city of Vallejo, alleging that they had a pattern of horrific misconduct. I should say this officer not only wasn't disciplined, he was promoted and then left the department after a few years to run his own police training business.
Oh, that's good. But well, I'm sorry. I just like that. He's standing on the hood of the car like he's in Grand Theft Auto, and he's he thinks he's like the Punisher or something like that, and he has his own training apparatus. I mean, this is why it's not just training; it's like defunding, and then also the ability to actually have civil litigation. I just have to say that that's what makes this is so systemic, but I apologize. Keep going.
And it is systemic, and it is important to see this not just as a problem of that officer who clearly was acting in a way that would be unimaginable to many law enforcement officers, even, but it was a product of a larger culture of the department where officers could get a celebratory badge bending ritual after fatally shooting someone, and no one was disciplined. This is a problem that goes not to the individual officers, or not alone to the individual officers, but to the entire city, the jurisdiction. And this is why it's so important to be able to bring cases directly against the city, to hold the city responsible for the department that it funds. And even though all of these cases, so many cases had been brought, 85 by my count in a decade against this department, and a small group of judges were hearing all of these cases, it was still not enough under the law that the Supreme Court has authored. It was not enough to hold the city responsible because the plaintiff couldn't prove that the prior shootings were unconstitutional. So there wasn't a pattern of prior unconstitutional conduct that would put the police chief on notice that he needed to do something different.
So in terms of municipal liability, right? I mean, is there any credibility to the claims that municipalities wouldn't have the deep enough pockets to withstand these lawsuits? Pretty sure the answer is no. I mean, in the Breonna Taylor case, I mean, was that different? Because I know that her family did get a settlement. But if you don't mind, expanding on that.
Yeah, so there are a lot of large settlements and judgments that we hear about in the news. And when those settlements are against a smaller jurisdiction, it will eat up a larger part of that jurisdiction's budget. Or more likely in really smaller jurisdictions, it will be an insurance provider that provides the payouts in those cases. But in the vast majority of cases, particularly cases that don't get that kind of public attention, the settlements and judgments are much smaller. And in cities and counties across the country that I studied, I found that payouts in these cases tend to amount to less than 1% of local government's budgets. And usually it is the local government's budget, not the police department's budget, that is being affected by these payouts. And if you compare this less than 1% in police misconduct payouts to the quarter or third of local government budgets that are spent on the police department's budget as a whole, I think it's really misguided to criticize payouts in police misconduct suits as potentially bankrupting jurisdictions when they really are a very small piece of the pie, and especially when there are many people whose rights are violated who get no vindication in the courts at all because of limitations like qualified immunity, among others.
Yeah, that was really more of a devil's advocate question. Lastly here, is there value in your eyes in, not trying to, I guess, circumvent municipal liability to make it just like siloed to a police department? Because say the municipality or the state or whatever, that gives them some sort of skin in the game of systemic overhaul for police, as opposed to maybe some potential kind of statutory carve out.
I do think that part of the challenge is figuring out where the best pressure points are, where the pressure points are for change. When it comes to who should pay in police misconduct suits, I actually don't think it should be the officer. I do think that there are statutes, like Colorado has experimented with requiring officers who've acted in bad faith to pay a portion of a settlement, $25,000 or 5% of a settlement or judgment. I actually think that's a good idea because it does give the officers some skin in the game while also making sure that the local government is going to be able to fully compensate the person whose rights have been violated. My inclination is that police departments should have the money taken out of their budgets. And remember, police departments' budgets are set during city budget planning processes.
Right.
So it's really money from the city that goes to the police department's budget. But I've spoken to risk managers and officials in some jurisdictions that do this, and they have said that knowing what is being spent and knowing that it's coming from their budget does make police departments a little more sensitive to the decisions that they're making. It's still just a small percentage of police departments' budgets, but they are directly able to make some changes if they choose to reduce the likelihood of future harms.
Well, this was so excellent. I can't thank you enough. Joanna Schwartz, professor of law at the UCLA School of Law, author of Shielded, How the Police Became Untouchable. We will put a link to the book in the description, podcast, YouTube, all those good places. Thanks so much, Joanna. Really appreciate your time.
Thanks for having me.
Of course.